Hi, welcome to Glorious IAS Academy. Today we are going to discuss about the part 2 of the fundamental rights. In yesterday's class, we were discussing about the little bit introduction, the concept of the fundamental rights and what are the important fundamental rights are there. There are 6 fundamental rights that are mentioned in the Indian Constitution. These will be covered from the Article 12 to 35. Those articles will be mentioned as the fundamental rights in Indian Constitution. In this video lecture, we are going to discuss about the first fundamental rights, right to equality, which covers Article 14, Article 15, Article 16, Article 17 and Article 18. There are 5 important articles which will deal with the only first fundamental right, only one right, right to equality. So these are the 5 articles mentioned here. If you look at Article 14, it is talking about equality of law, equal protection of law. And Article 15 is talking about the prohibition of discrimination on the grounds of religion, race, sex and caste. So Article 16 is talking about the equality of employment and equality of opportunity in the matters of the public employment. In the public employment, that means the government employment, every citizen of the country would be equal. So every citizen of the country would be provided equal opportunities in the matters of the public employment. Article 17 is talking about the abolition of untouchability. You know very well there are depressed classes of the society like STs, scheduled caste, scheduled tribes, and it may be children or women. They were suppressed over the thousands and hundreds of years in Indian society. So a lot of discrimination meted out with them, and subsequently they were treated as slaves in the industries and in the homes. So these sections of the society, they are discriminated in the every walk of life. So after we got the independence, the Constitution came into force in 1950. So the Constitution implemented certain measures, inserted certain fundamental rights which will lead to the abolition of untouchability. So untouchability does not mean is a physical literal meaning, but untouchability according to the various Supreme Court and High Court judgment, untouchability nothing but the practicing the discrimination against the certain class of society, and they do not have access to they do not allow to access to the certain kind of public amenities like wells, like roads, like some etc. And also there is a class and caste discrimination in the society. So all this comes under, all this will come under admit of the untouchability. So Article 17 is talking about the prohibition of the and abolition of the untouchability in every walk of life in the Indian society. Whoever practicing the untouchability, it may be state, it may be private individual, it will consider as an offense. So time to time the government of India enacted some special legislations to prohibit the untouchability in the Indian society. So one of the best example, Civil Protection of Civil Rights 1955 and SC Scheduled Caste and Scheduled Tribes Prevention of Atrocity Act in 1987 and 1986. So these are the important legislative actions taken by the government of India in order to abolish the untouchability in the Indian society. So next one, abolition of titles. You might be knowing that during the British government, during the British era, previously the days before the British era, there were some titles given by the Britishers to the local jamindars, local kings. For example, if you take the Nizam Nawabs, they have given some particular titles, Nizam of Nawab, like that. They were given some particular titles in order to provide certain kind of support to the British provinces. Britishers were ruled India 50% directly, 50% indirectly through the princely states. And local jamindars, Raja Bahadur, like titles were given to the local Rajas. So these kind of titles would be abolished. Why? Because why there is a need of abolition of titles? This title indicating the inequality in the society. So everybody is equal under the Constitution. In the Indian society, every person will be treated equally. Nobody is above the law, nobody is below the law. Everybody equal under the law. So that's why these titles are indicating the special privileges that given to the some sections of the society. So abolition of the titles, one of the fundamental right under the right to equality. Now we are going to discuss about these articles one by one, and also certain kind of exemption given to certain kind of persons. Every article will have some certain kind of exemptions. Article 14 will have some exemptions, Article 15 will have some exemptions. So now we are going to discuss every article, what is the meaning of the every article, and what are the certain kind of exemption given for this article, and what are the measurements, what are the actions or programs implemented by the government of India to implement these fundamental rights across the Indian society. And also we will going to discuss about some of the important judgments given by the high courts as well as the Supreme Court to implement to protect these fundamental rights. Now let us take first article, Article 14, right to Article 14 under the right to equality, and Article 14 would be divided into two parts. First part is equality before law and equal protection of law. So equality before law is the British origin. We have taken this concept from the British Parliament, British Constitution. So equality of before law, this concept has been taken from the British Constitution. What do you mean by the equality before law? Equality before law, nothing but every person and every citizen of the country would be treated equally in front of the law. There is no person above the law, there is no person below the law. And it is indirectly telling that everybody ruled by set of rules and regulations that are framed by the Constitution as well as the Indian Parliament as well as the state legislatures. So these rules and regulations that are framed in the law, they will be applicable to the each person equally, and nobody will be treated and nobody will be given special privileges, special rights in the under the Indian Constitution. That is the real meaning of the equality before law. So we are indirectly ruled by the rule of law. What do you mean by rule of law? Rule of law is the proposed by the A.V. Dicey, is the British jurist. Rule of law, nothing but we are indirectly ruled by the law. Every person, every citizen in the country ruled by the equal law. So that's why this equality of law belongs to every single individual. It is belongs to available to every single individual. So absence of the special privileges in favor of any person. No person is above the law. And what do you mean by the equal protection of law? Law would be protected everybody equally. For example, law would be protect equal. Sarabjan, a competitive exam would be conducted for the UPSC exam, for the IAS exam, for the filling the IAS, IPS and some other services. So for this competitive exam, everybody would be treated equally. No special privilege will be given. But in certain circumstances, some special provisions will be provided to certain class of the society. For example, scheduled castes are there, scheduled tribes and handicapped people are there. So they are the financially, socially backward people in this country. Law can protect everybody equally, but there are certain sections of the people in the Indian society, they will be discriminated. They will have certain kind of disadvantages. In order to balance these disadvantages, in order to balance this discrimination, certain kind of special privileges, like for example, best example is the reservation would be provided. 27% reservation would be provided in the public employment for the OBCs, and certain kind of reservation would be provided by the STs, certain kind of reservation would be provided by the SCs and economically backward sections. So these are some of the exemption given under the Article 14. So equal protection of law, nothing but equal treatment of law, equality of treatment under equal circumstances. You cannot treat everybody in the same circumstances. So you cannot put a same competition for the handicapped people and the normal people. So that's why they will provide certain kind of reservation. So the equality before law means equal protection of law, nothing but providing certain kind of balances while implementing the law. Next, the both in privileges and liabilities imposed by the law, and likes should be treated like likes without any discrimination. And this article is available to the group of people. This is belongs to the single individual and this is applicable to the group of people. And there are certain kind of exemptions are there. So as we discussed, A.V. Dicey proposed the rule of law. So equality before law, whatever included in the Article 14 of the Indian Constitution, is the part and parcel of the concept of rule of law. Rule of law has a 3 elements and of which only 2 is applicable to the Indian system. What are those 2? Absence of arbitrary power. What do you mean by arbitrary power? State cannot misuse its power. State cannot misuse its power. The state government or the central government, parliament or legislation should use the power in a equally manner, means that should use this power to every citizen in the equally. There should not be any arbitrary usage of the power. Means the all government actions and all government legislations should be treated every citizen equally. Some people should not enjoy the more power and some people should not enjoy the less power. So the power should be distributed equally. There should not be any arbitrary usage of the power by the state. That is the first part of this concept of rule of law that will be implemented to the Indian system. Second one, equality before law, we have already discussed, and some of the exemption given to the persons under the Article 4, some important persons. What are those? First one, president and the government will be given immunity or privilege. So as a president of India and a governor, they cannot be arrested while they are discharging their duties. So while they are holding the highest offices, because they are holding the highest offices, the constitutional positions, so they would be given some certain kind of exemption under the Article 14. Second one, true facts of the reports. Third one, MLAs and MPs, because they were elected by the people and there should be certain respect towards the people representatives. That's why they have given some exemption under the Article 14. And next one, Article 31B, we have already discussed Article 31C, and these related to the land reforms. The government implemented the land reforms immediately after the independence, and land is taken away from the zamindars and big landlords and distributed among the other sections of the people by inserting Article 31B and 31C. So this is related to the land reforms. These are related to the implementation of the Directive Principle of State Policy, DPSP. So these are the 4 that are exempted from the Article 14. And next, Article 15. What Article is 15 is talking about? That is called, state shall not discriminate against any citizen on the only grounds. Only means the grounds mentioned in the Article 15, not the grounds that are not mentioned in the Article 15. Only on the grounds, number 1, religion, number 2, race, number 3, caste, number 4, sex, and number 5, place of birth. Here the only means other grounds are not protected. Only the discrimination shall not be there on this, only on these grounds, not other grounds. So that is the meaning of the Article 15. And state, no citizen shall be subjected to any disability, any liability and any restrictions or conditions. What are those conditions? Access to public shops, access to public restaurants and hotels and place of public entertainment, as well as the usage of wells, tanks, bathing and etc. So by accessing and using usage of this kind of public places, it may be shops, it may be shopping malls, it may be any other parks, and these access and usage of these all public amenities should be distributed equally to all citizens. There should not be any discrimination in the accessing and usage of these particular facilities. So that is the real meaning of the Article 15. And certain kind of exemption given to certain kind of the people. What are those exemptions? First one, women and children were exempted from the Article 15. What do you mean by the Article 15? It is a right against the discriminations based on certain grounds. So women and children will be exempted from the Article 15, and socially and educationally backward classes, second sections of the people, and third one, SC, STs, and fourth one, advancement of the means economically weaker section. How they are exempted? Because in terms of the reservation. See, we are talking about the reservation is the some kind of exemption given under the Article 15 as well as Article 16. So we have women reservation. Recently the Parliament of India passed the bill in the both houses of the parliament to implement the 33% of reservation in the MLAs and MPs, means in the election of the MLAs and MPs in the public representatives. So the women will going to get the 33% reservation in the MLAs and MPs, like SC, ST people have already got. So this is the best example for the exemption from the Article 15. You should not discriminate anybody, but in the certain kind of circumstances, in order to protect the certain kind of sections of the people, in order to advancement or upliftment of the downtrodden sections of the people, you need to implement certain kind of the programs, certain kind of the schemes like reservation. So in order to create equal society in the India. So that's why certain kind of exemptions were provided under the Article 15 in order to upliftment and advancement of the backward people in the country. Number one, reservation. How these exemptions were implemented? First one, reservation for the OBCs in the educational institutions were implemented. So the exemption used under the Article 15C. Under Article 15C, by using the exemption under the Article 15C, 93rd Constitutional Amendment Act 2005 was passed by the Parliament, and two things were implemented by using this Constitutional Amendment Act 2005. First one, Central Educational Institutions Reservation in Admissions Act 2006 was enacted, and along with this act, 27% reservation for OBCs in all central higher educational institutions, including IITs and IIMs. So this is the one of the exemption provided under the Article 15 of C. Another exemption used under Article 15D, reservation for EWS sections of the people, means economically weaker sections in the educational institutions. How? They added 103rd Constitutional Amendment Act. The Parliament passed the 103rd Constitutional Amendment Act in 2019, and 10% reservation provided to economically weaker sections in the admission to educational institutions was introduced. So far, many times the exemptions were used under the Article 15, even though it is discriminatory in nature, but in order to establish equal society, in order to promote the welfare for the certain kind of the people, in order to advancement of the downtrodden sections of the people like women, people like children, people like handicapped persons, SCs, STs and economical weaker sections, and they were provided certain amount of the reservation time to time. So overall, if you calculate the reservation, now SCs provided 15%, STs provided 7.5%, and OBCs got 27%, and physically handicapped persons got 3%, and EWS section people got 10% of the whole in the educational as well as the public employment. So this reservation provided by using the exemptions under the Article 15, and same applicable to the Article 16. What do you mean by the Article 16? It is the equality of opportunity for all citizens in the matters of public employment and the appointment to any office under the state. So it is more or less addressing the employment opportunities. What do you mean by employment opportunities? So equal employment opportunities should be provided under Article 16. So what are the principles of equal employment opportunities? Number one, in getting a job, equal employment opportunities would be provided, and a equal working environment should be provided to the all people, and equal relationship dynamic at the work should be there, and process of accessing performance, the performance assessment should be done in equal for every public employee, and potential for the career advancement and training. So these are the principles comes under equal employment opportunity. And what are the exemptions? Now we are talking about every article elaborately. What is the meaning of the article, and what the inner meaning of that article, and what are the provisions of that article, and what are the exemption given under this article. So like that we have already discussed Article 14 and Article 15, and Article 16. What are the exemptions? First one, son of soil doctrine. What do you mean by son of soil doctrine? Son of soil theory is talking about the right to have special rights for the local people over their culture, over their employment. So a certain kind of the people living in a certain particular place, so they will enjoy certain kind of special privileges in that locality. You take the example of Andhra Pradesh. So only 10% or 15% will be allowed, outsider will be allowed in the public employment, and whole 95%, around 85 to 90% will be in the state government jobs will be provided Andhra Pradesh citizens itself, Andhra Pradesh people itself, and no other will be allowed into the Andhra Pradesh state government except few. So this is called son of soil doctrine. Son of soil nothing but having special privileges and rights over their own in the for local people in their locality. It may be over the culture, it may be over the employment, it may be over the land, whatever it may be, the having the special rights for the people, local people over their own resources. So that is the under the son of soil doctrine, one exemption would be provided under the Article 16, and reservations for the appointments are post in favor of backward people. We have already discussed, this is one of the exemption under the equal employment opportunity should be provided Article 16. But in order to, we have already discussed that in order to provide some advancement and provide some welfare to the certain kind of societies, certain kind of classes in the society, the reservation is provided by using the exemption under the Article 15 as well as the Article 16. Next one, office of the religious or denominational institutions should be belongs to particular religion and denomination. Why? Because if you clearly observe this statement, for example, Hindu temple is there, sometimes other sections people will not be allowed. There should not be any discrimination, but under certain circumstances, religious denominations will be religious, some particular religious places, other religious people will not be allowed. That will not comes under the discrimination, that will comes under the protection of their own religion. Protection of their own religion. So this is one of the exemption given under the Article 16. And next one, the reservation, recently the reservation provided 10% of reservation provided for the EWS. So Article 15, the exemptions given Article 15 and Article 16 more or less talking about the same exemptions. So by using this exemption under the Article 16, government has taken some of the measures. First one, National Backward Classes Commission. This is called National Commission for Backward Classes. By using the exemption under the Article 16, the government appointed National Commission for Backward Classes. The first commission appointed established in 1953, and after that Mandal Commission second time in 1979. Mandal Commission was appointed by the central government to look into the conditions of socially and educationally backward classes and suggest the measures. So first time the government of India, by using under Article 16, by using the powers under the Article 16 in 1953, first backward commission was established under the chairmanship of Kaka Kalelkar. Kaka Kalelkar, remember this name, Kaka Kalelkar. And second time in 1979, Mandal Commission, this is called second backward class commission, was constituted under the chairmanship of BP Mandal by using the Article 340. Article 340 was inserted in the Indian Constitution. What is the purpose? To investigate into the socially and economically or educationally backward classes conditions and suggest certain kind of measures. Very important thing, this Mandal Commission recommended 27% of the reservation to the other backward classes in the government employment. So according to the Mandal Commission recommendations, in 1990, VP Singh government, VP Singh was then Prime Minister of India, he declared that 27% of reservation for the OBCs. And subsequently, this reservation also extended to the economically weaker sections, and PV Narasimha Rao in 1990, VP Singh was introduced 27% for the OBCs. In 1991, PV Narasimha Rao became Prime Minister of India, and he extended the same reservation, 10% reservation to the EWS, economically weaker sections, and poorest of the poor in the higher caste in India. So 10% poor sections of the high caste. But few persons belongs to society. Few members challenged this implementation of reservation and Mandal Commission recommendations, and they went to Supreme Court, and Supreme Court given the judgment, very important judgments on the Mandal case. So that was popularly known as Mandal case 1992, scope and extension of the Article 16 of 4. The Supreme Court expanded the scope of Article 16 of 4. First one, the court rejected the additional reservation for the 10% for the poorer sections of the higher caste. So there are two important judgments given. First one, it rejected the 10% reservation, and also it given permission to the 27% reservation, but imposes certain restrictions on this 27% reservation. So Mandal Commission, in the Mandal case, Supreme Court given two important judgments. Number one, it abolished the 10% reservation for the EWS, which was implemented by the P.V. Narasimha Rao government in 1991. Second one, it allowed the 20% reservation for the OBCs under certain circumstances, certain conditions. It imposed some certain restrictions on the 27% reservation. What are those? The court introduced the creamy layer among the OBCs. Second one, no reservation in the promotions. There should not be any promotions, any reservation in the promotions. There should not be any reservation in the promotions. Third one, the total reservation should not exceed 50%. It may be inclusion of SC, ST, OBC. What kind of reservation? The total reservation should not exceed 50%. Next one, the carry forward route would be implemented. The carry forward means if some post related to the reservation would not be filled, there is no qualified conduct, those posts will be carried forward to the next notification. So the carry forward rule will be implemented, can be implemented by the government according to the Mandal case. Next one, a permanent statutory body should be set up by the government in order to look into the conditions of these particular sections of the society time to time. So these are the 5 important conditions imposed by the Mandal Commission. Here we are talking about the Article 16, nothing but providing equal opportunities in the public employment. So government provided and certain kind of exemption given to the certain kind of society, certain kind of the classes like women, SCs, STs and OBs. And according to the exemptions, the government appointed first National Commission for the backward classes. Second, government 2 times appointed this commission, and second time it is called Mandal Commission. So Mandal Commission recommended the 27% for the OBCs, and according to the Mandal Commission, government implemented the reservation, and this reservation challenged in the Supreme Court, and Supreme Court subsequently abolished the 10% reservation to the EBCs and allowed the 27% for the OBCs under certain conditions. So what are the government steps taken regarding the Mandal case or SC ruling? First one, Ram Nandan committee was appointed to identify the creamy layer. Supreme Court imposed certain restrictions. First restriction is creamy layer. The government should not implement this reservation, 27% reservation to the creamy layer. What do you mean by the creamy layer? Creamy layer nothing but those who are already developed sections in that particular community. So in the OBCs who are already got the fruits of the reservation, and those who are already elevated financially, economically, socially in that particular OBC sections, they will not get the reservation under the creamy layer. So Ramdan committee was appointed by the government to identify the creamy layers under the OBCs. And the Mandal case, Supreme Court also suggested the government that appointing the permanent statutory body. On the lines of the judgment, government established National Commission for Backward Classes in 1993. 102 Constitutional Amendment Act, it has conferred the constitutional status. Under Article 16(4)(a), 77 Constitutional Amendment Act also passed by the Parliament, and reservation in promotion also implemented to the SCs and STs. And under another article 16 of 4 of B, 81 Constitutional Amendment Act passed by the Parliament, and according to this Constitutional Amendment Act, states should consider the fulfill reserved vacancies of a year as a separate class of the vacancies. What do you mean by separate class of vacancies? Means carry forward rule. If certain vacancies will not be filled and those vacancies will be filled in the next year, those vacancies will be considered as separate class of vacancies under the Article 14 of B by the 81st Constitutional Amendment Act. So these are the next one, it ends the 50%. If you implement the carry forward rule or special class of vacancies, it automatically ends the 50% of 50% cap that is imposed by the Supreme Court in the Mandal case. So by the 81 Constitutional Amendment Act, it ended the 50% rule imposed by the Supreme Court, and also recently the reservation for the EWS quota, means economically weaker sections in the public employment. So like that 103rd Constitutional Amendment Act provided the 10% reservation to the economically weaker sections in the civil posts and services of the government of India. So these are the some of the measures that has been taken by the Indian government according to the ruling of Mandal case, according to the Supreme Court judgments. So in this class we have discussed Article 14, 15, 16, and next part of the class we were going to discuss about the Article 17 and 18 of right to equality. Thank you very much.